Romany Sutherland represents Mrs. H, a mother that's been really talked about in South Africa this week. This mom, Mrs. H, is mother to a Down syndrome child, and the mother is arguing through her legal team in the Constitutional Court a claim of wrongful life. Romany's here to talk us through it. Romany, why don't you just start us at the beginning and talk us through this case?
Okay, I was approached by Mrs. H, and that was approximately 3 years and 8 months after her minor son was born with Down syndrome and cardiac defects. And that was the first time she realized that she was going to have a Down syndrome child. So the problem, and why I say 3 years, is that had she come to me within the 3 years, she would have had a claim on her own for herself. Okay, and that claim is called a wrongful birth claim. That is recognized in our law, and it has been for quite some time. Now, the problem comes in, she came to me after the prescription period of 3 years. So we then looked into a case as to whether the child, the fetus, or the child, M, had a claim in his own capacity. Bless you.
Excuse me. Sorry.
Okay, so what happened is Mrs. H fell pregnant. She then went to the fetal assessment center, and specifically because she was a little bit older, she went to them and she said, please, I want a scan done to see if there are any sort of chromosomal defects. And the one doctor at the fetal assessment center said, did the scan, did the measurements, and said everything looks absolutely fine, proceed with the pregnancy. She then gave birth and realized child was Down syndrome and also had severe cardiac defects. Now that is often associated with Down syndrome. And what we then did to find out if there was a claim for negligence is we approached another fetal assessment doctor or specialist. And what I did, I just said, didn't give any sort of history of the case. I just said to this lady, I said, just open the scan and tell me what you see. And what she actually did, she opened the scan and she said, I can tell you now that this fetus is a very, very high risk of Down syndrome. And you can even see the cardiac defects. Now the problem is, that scan was interpreted incorrectly. You see. So that's where the negligence is. We're not talking about the fact that these tests do have sort of a certain percentage of inaccuracy. We're not talking about it. We have a scan that has been interpreted, was very clear on the scan, but it was interpreted incorrectly. Right. Okay, yeah.
Carry on, please.
Okay, so then the big problem here, as I said, the mom would have had a claim that's called wrongful birth, which is recognized in our law. So that's a claim as a result of the negligence. There are damages suffered. Okay. Now, what we don't recognize in our law is something called wrongful life, and what we call wrongful suffering, because wrongful life, it's a terrible term to use because we're not saying that this life is wrong. We're saying that this life is a life of suffering. Okay. And we've had those words, wrongful suffering, in our court papers as well. And we believe that the Constitutional Court has accepted that term, well, we hope. So what we're trying to claim here is that the minor has a claim for the suffering that he has now. Okay, he has a life of suffering. Now, the big difficulty in our law and why it isn't recognized, it is recognized in quite a few of the progressive countries in the world, the Netherlands and Italy, and also it's quite ironic because we're Roman Dutch law, and those two countries recognize this wrongful life or wrongful suffering claim, as well as the United States, Belgium, and Israel. Now, but what they've done is they've also been faced with the same problems of how to quantify the damages, how to quantify, well, usually in our law we look at, had the negligence not occurred, where the person would be. Now that the negligence has occurred, where the person is, that difference is usually the compensation. Now in this case, we're saying, had the negligence not occurred, there would be no life. How do you compute that to where he is now? But that is what we believe archaic way of thinking of it. We want the courts to look at the assessment of damages. The fetal assessment doctor said to this lady she was having a perfect child compared to a child now with disabilities. And the child is going to cost money. That's what it's about. It's going to have special needs, special school, therapies, extra care, 24/7 care. There's extra funds that are now needed to be sort of spent by this family. And we get back to the fact that she was never given the choice of termination of pregnancy, which is perfectly legal and recognized in our country with the Choice of Termination of Pregnancy Act. So our case in the Constitutional Court is that based on human dignity, the right to bodily and psychological integrity, and the right of disabled children not to be discriminated against. And on top of that, the fact that the rights of children and the interests of children are to be protected. They are paramount. We do believe that we don't see how this cannot be accepted. So that's our case that we've given put up to the Constitutional Court, and also the mere fact that wrongful birth is recognized. It's almost exactly the same facts, and wrongful suffering is not. So that's what we've put to the court, and they've got a very difficult decision to make.